Hey, thanks for clicking on Gary the Lawyer. First, the fine print and legalese disclaimer. Look, I'm not your lawyer, and you should not consider this to be good legal advice. In other words, don't do anything that I'm telling you to do without first seeking the advice of a competent attorney. Today I want to talk to you about how not to get sued. It's about prevention. It's about keeping your hard-earned money out of the hands of greedy lawyers. Did you know that the largest single plaintiff jury verdict in California was for sexual harassment against a hospital, specifically complaining about doctors' inappropriate conduct? You just have to read a couple of legal journals to realize that medical office setting seems to be the breeding ground of bad behavior. You're so smart to have medical malpractice insurance, comprehensive general liability insurance, workers' compensation insurance, and automobile insurance. However, you probably don't have employment practices liability insurance, or EPLI insurance. The only other type of insurance that will insure you for claims of sexual harassment, discrimination, and retaliation. So practice what you preach. Practice preventative dentistry. Prevent these types of claims by doing the following. First, create a harassment, discrimination, and retaliation prevention policy for your practice, and have it signed by each employee and placed in their personnel file. I'll give you an example of such a policy in the Chairside Live magazine. This is not just for your employees, it's also for any jury that might decide your case. You want everyone to understand your commitment against harassment, discrimination, and retaliation. If you're on the fence about whether to create such a policy, understand that the creation, contents, and distribution of such a policy is now mandatory in the People's Republic of California. So if your business is in California, you need to consider fleeing our state or developing such a policy for yourself. Next, provide training regarding discrimination, harassment, and retaliation to your employees. Almost any employment or general practice law firm or your Chamber of Commerce will have harassment and discrimination training courses available. And any lawyer you work with who's interested in keeping your business will probably provide that training for free or for a reduced cost. Note again that in California, training is mandatory, if you have 50 or more employees, that is. So while that requirement probably does not apply to most dental offices, it's still a very wise course of action showing that you are being proactive. Finally, prohibit all employee discussions about the personal characteristics of other employees, patients, or contractors. It's easy to say that you cannot discriminate, harass, or retaliate against any employee based on any protected category, such as race, gender, disability, national origin, color, and so forth. And for a complete list of the California protected categories, see the example policy that I'm going to give you in Chairside magazine. And understand that in the broadest manner possible, this means that, under the law, you cannot take any adverse job action, such as refusal to hire, refusal to promote, or termination based on any of those protected categories. However, and pay attention now or pay a lawyer later, from a simple, practical standpoint, this means no joking, no commenting, no discussing any personal characteristics of any employee and insisting that your employees avoid the same. After all, the protected categories are made up of nothing other than the personal characteristics of the employees. So for the big question, can you discriminate against lawyers or make lawyer jokes in the office? Answer, yes. Being a lawyer is not a protected category, but you should refrain unless they're good jokes. To conclude, here are my top recommendations to dentists for keeping plaintiffs' lawyers' hands off of your hard-earned money. 1. Have a written policy against discrimination, harassment, and retaliation. Have it signed by each employee and put it in their personnel file. 2. Ask a friendly lawyer for some free training on this topic for your staff. 3. Understand that you cannot discriminate, harass, or retaliate against any employee based on any protected category. 4. Understand that number 3 really means no joking about, no commenting on, or discussing any of the personal characteristics of any employee, and prohibiting your employees from doing the same. 5. Check with your insurance broker about EPLI insurance. My broker told me the typical policy will cost about $5,000 in annual premium for a small dental practice. 6, be consistent and fair. Ask yourself how a jury would view your actions with your employees. You want the answer always to be as a nice, reasonable employer. 7, along those same lines, act and speak in a manner that you would approve of seeing replayed on a video in front of a jury. Remember, almost everyone has a video camera recorder in their pocket. 8, hide any natural inclination towards favoritism. Favoring one employee often equals discrimination from the perspective of the other employee. Number 9, hire very cautiously. That means reference checks, drug tests, and background checks to the extent you can legally do that. And get legal advice prior to terminating bad employees. Number 10, always set the example from the top. Good luck out there. Email me if you have any questions or comments.